Hi everyone, my name is Becky Knott and I'm a barrister at Hogarth Chambers, specialising in intellectual property. Before I qualified as a barrister, I qualified as a trademark attorney and trademark attorney litigator, and I am a member of CITMA and a member of the CITMA Council. And I'm here today to give the first CITMA Vodcast, which is going to be on Sky and SkyKick. So, what's our agenda for today? Well, as I said, I'm going to give you an update on the fairly recent judgment of the Supreme Court in Sky and SkyKick. And I'm going to start off with just giving you a flavour of the case and why we're looking at it. Then I'm going to move on to bad faith, what it is. And thirdly, look at a bit more of a detailed background to the case, what happened, the key findings. And then after that, look at the takeaways. Where does the judgment leave us now? That the dust has settled a little bit. So moving to what the case is about. Well, the Supreme Court's judgment in SkyKick was the culmination of a long-running dispute starting back in 2016 and resulting in a total of 9 judgments and 1 Advocate General opinion. As you may imagine, there were many issues in the case over its life, but the issue that we are going to consider today, and the reason why the judgment was so hotly awaited, is bad faith, and specifically whether Sky had acted in bad faith by filing for the registrations it relied on in its claim. And what is really remarkable about this claim, and what triggered the counterclaim for bad faith made by SkyKick, is the size of Sky's registrations, and adding to that, the way in which it chose to enforce them. And to give you an idea, the longest specification relied upon by Sky in the claim ran to an enormous 8,255 words, which is pretty long. And most of the specifications also contained a very large number of class headings, and to boot, spanned a vast range of goods and services, including, as I'm sure you've heard about, the infamous whips, bleaching preparations, as well as very broad terms such as computer software. So all of this raised the question, is it bad faith to file applications of this nature? Some of the goods covered, such as whips, Sky was clearly not using, clearly not going to use, clearly had no commercial rationale to use. But taking a step back, why is this a problem? Well, we operate a first-to-file system in the UK, and in addition to that, once a trademark is registered, that proprietor of the trademark has 5 years before the trademark can be challenged for non-use. This has some really great benefits, for example, allowing a proprietor to stagger the rollout of its commercial strategy. But what it also means is that effectively, it can result in a period where you have an untouchable registration for an enormous specification which you don't intend to use. And is this bad faith? This is a particularly sharp point of public policy because, as you may be aware from practice, from things like filing and searches, the trademark register is very cluttered. There's a concern, as a result of that cluttering, about a growing trend of extremely long specifications and evergreening on top of that, which, if you don't know, is where a proprietor refiles for the same trademark with the purpose of avoiding use requirements, for example, proof of use in an opposition or genuine use in a revocation attack. And the concern coming off of this is that the use strictures, so those requirements to evidence use, don't provide a sufficient balance. 5 years is a very long time. So what do you do if you are an applicant being faced by a mark that's under 5 years old that you can see isn't being used and you think was filed purely defensively? Well, the hope is that bad faith can step into the gap and deal with any such applications that have been made without a genuine intention to use. Moving then on, what is bad faith? Let's take this in framework go back to the beginning. Well, we find bad faith referenced in Section 3(6) of the Trademarks Act 1994, which states pretty simply that filing for a trademark in bad faith is a ground for refusal. And don't forget that this is also a ground for invalidity by way of Section 47, subsection 1, subsection A. But as I've said, it states it in pretty simple terms, and the Act does not explain what bad faith means. As a result, we have to look at case law to try to understand the meaning, which makes our lives quite difficult as it's not exhaustive. But as a general overview, bad faith is all about intention and the nature of that intention. And what we're really getting to when we make a finding of bad faith is some presupposition as to the presence of a dishonest state of mind. To give you a little bit more colour on that definition, the Red Bull case, which I've put out on the slide here, gives us quite a good overview, and you may well have seen this cited in many registry decisions because it's a very helpful overview. I can't go into the case in full as we're already on a bit of a whistle-stop tour with SkyKick alone, but I suggest if you haven't read it that you go away and do so. And in particular, the key paragraphs for our purposes are at paragraphs 130 to 138 of that decision. But summarising those paragraphs, those key principles, what you have to bear in mind when you're considering bad faith are a number of things. Firstly, that the relevant date for assessment is the filing date for a trademark. So you have to look at that date of filing, although later evidence beyond the filing date can be relevant to shed light back on the filing date. Secondly, there is presumption of good faith. So a person is presumed to have acted in good faith unless the contrary is proved. And thirdly, thinking about that proof, the case law is very clear that an allegation of bad faith is a serious allegation which must be distinctly proved on the balance of probabilities. Cogent evidence is required because of that seriousness, and it's not enough to prove facts which are also consistent with good faith. Considering again then intention and the nature of that intention, I mentioned on the previous slide that dishonesty is important, but you should also be aware that bad faith includes not only dishonesty, but also some dealings which fall short of the standards of acceptable commercial behaviour observed by reasonable and experienced men in the particular area being examined. And that quotation is from the Gromax case, which you may have come across. Lastly, the intention of the applicant is a subjective matter, but it must be capable of being established objectively. So you cannot simply accuse a subjective intention. You do need some evidence which sets up an objective framework. That's a very quick stop through the principles, just to give you a flavour of what bad faith is. But before I move on to SkyKick itself, I want to emphasise as well that bad faith can take different forms of abuse. And Lord Kitchen, in the Supreme Court judgment for SkyKick, set out two main categories, which is a very useful way of thinking about bad faith and framing it if you're looking at defending or alleging it. So those two categories, category one is effectively where the application is made to undermine the interests of third parties. So there's some kind of direct attack, not engaging fairly in competition. So perhaps there may be an allegation of trying to block your client, for instance. Category two doesn't require a specific third party to be under attack. It's more about a misuse of the system. So an applicant not obtaining a right in accordance with the functions of a trademark. That might be, for instance, the evergreening point. And that category two is really what we're going to talk about today. And what that abuse, that misuse of the system is really speaking about is a lack of intention to use. So not acquiring a trademark to use as a badge of origin, but for some other purpose. And that might be that evergreening point, circumventing use strictures. Before I move on to the next slide, as a headline, I am just going to say that ultimately, I don't think that the Supreme Court's judgment has made it easier to prove bad faith, but we will get to that. So moving to the next slide and the background of the case. This is the citation for the High Court's main judgment where bad faith was found. And that was Mr. Justice Arnold, as he then was. And in this decision, he found that Sky's registrations had been made partly in bad faith. And following cross-examination at trial, which if you do want to have a look at is quite interesting, quite entertaining, Mr. Justice Arnold found that Sky did not intend to use its trademarks in relation to all of the goods and services covered by the specifications. And he grouped that lack of intention to use into 3 different forms. Firstly, specific goods that Sky had no intention to use the trademark for at all, and there's your infamous whips and bleaching preparations. Secondly, goods and services which were so broad that Sky simply could not and did not intend to use the trademarks for across the breadth of the category, and that's terms such as computer software. And thirdly, parts of the specifications where they were intended to cover all of the goods and services in the relevant classes, so using class headings. And the judge gave an example of class 9 for this. Following that High Court judgment and that finding of bad faith, the case was appealed up to the Court of Appeal, and the trial judgment was overturned by the Court of Appeal, which in very brief held that a lack of intention to use on its own does not amount to bad faith. And secondly, that mere breadth of specification of goods and services is not an indicia of bad faith. And this was then appealed to the Supreme Court, which moves us onto the next slide. Setting the stage, the central question for the Supreme Court was, is a lack of intention to use at the time of filing bad faith? And if it is bad faith, what's the consequence of that? Does a finding of bad faith for part of a specification infect the entirety, or does it lead to partial invalidity, as was found in the High Court? And really, I think this breaks down into 2 main points. Firstly, an assessment of the position where there's no intention to use at all. And secondly, the position where you have very broad general terms and categories. And as a spoiler, in case you're not already aware, that Court of Appeal judgment finding that a lack of intention to use isn't bad faith on its own, and breadth is not an indicia of bad faith, was overturned by the Supreme Court. And that brings us into the main findings of the Supreme Court. The Supreme Court confirmed, as I've just mentioned, that a lack of intention to use can constitute bad faith. And there's an extensive setting out of all the principles of bad faith. It is a really useful, albeit long, judgment to read. But Lord Kitchen, who gave the judgment, confirmed when setting out those principles a few really important points for the findings that he then went on to make. One of these is that it's not possible to presume bad faith purely on the basis that at the time of filing, the applicant had no economic activity corresponding to the goods and services. So you don't have to be using at the time you file. And following on from that, again, quite an important point, it's not necessary that an applicant knows at the time of filing precisely the use that's going to be made of the trademark. You don't need a firm or settled intention to use. That lack of a firm or settled intention to use will not of itself undermine the validity of your trademark. And we can see really that this is going to fit in with a lot of filing strategies, which is often the way you do it is that you try to consider the longer term goals of what your client might go into. So you may set up with your client what are your short, medium, and long term goals. How can we protect your interest best as we file your trademark application? The interesting point is that this seems to flow throughout the 5-year period so that you have those 5 years to firm up your intention. But importantly, this is clearly distinguished by Lord Kitchen from cases where the applicant is not using and did not intend to use the trademark. He emphasised that the grace period is important, but it is for genuine applicants and proprietors, and the situation is very different if there is no intention to use. So, for instance, circumstances where the goods and services are different from anything that you might sell or might provide or wish to provide in the future. So it may then be bad faith, where you file without an intention to use, where there is no rationale for the application. And in appropriate circumstances, the applicant or proprietor may need to provide a satisfactory explanation for the application. But how do you determine this? Well, in the trial judgment, Mr. Justice Arnold had evidence which came out in cross-examination, and that's why I said it's quite worth reading through that particular judgment in the SkyKick chain, because it's quite interesting, the findings that were made on that. But you're not always going to have cross-examination, and you're not always going to have, following cross-examination, clear evidence of no intent to use. So what else do we do? Well, the Supreme Court also ruled that the breadth of a specification can, in and of itself, be an objective indicia of bad faith, and that can be sufficient to rebut the presumption of good faith, then putting the onus on the applicant to explain, although it's always going to be a matter of degree. But the central question, and this is found at paragraphs 255 to 256 of the judgment, is whether, absent an explanation and rationale consistent with the functions of a trademark, it is reasonable to infer from the size and nature of the list of goods and services and all other circumstances, including the size and nature of the applicant's business, whether it's possible to conclude or infer from that application is an abuse of the system and therefore was made in bad faith. And that statement is very useful, as it gives us some relevant factors to consider whether breadth is enough to make out bad faith. And I've set out on the slide that those two things, size and nature of the list of goods and services, and the size and nature of the applicant's business. And a third point might be then whether it is possible to provide an explanation for the application that is reasonable and gives you a rationale consistent with the functions of a trademark. So really what we're thinking about there is this a genuine exploration of viability over the 5-year grace period, or has this application been filed as a legal weapon? And what's very important to remember here is that lack of a reasonable explanation and justification can then reinforce an inference of bad faith. As a factor that does not assist you with rebutting bad faith, the Supreme Court confirmed that reputation is not a factor that works in the owner's favour. So that does not justify applying for goods and services where you have no intention to use. The Sky ran the argument that it's so big, it's got such a large reputation that it needs to protect itself in all these different categories. The Supreme Court had none of that. Stepping back, what does this all mean? Well, to give you just a practical example, if I start up a clothing business and I file a trademark which covers purses, cosmetics, jewellery, so not something that I'm offering at the moment, that could quite reasonably fall within an unsettled intention to use. It would seem to be fairly relevant to my business to move into those other products. But if I also include goods and services such as petrol, engineering services, fire extinguishers, then that 5-year period for development is unlikely to assist me, because I would seem to have no genuine intention to use the grace period to shore up my business. And if that presumption is raised against me, I am unlikely to be able to provide a satisfactory explanation. So all of this is to say that filers of trademarks can use the grace period to establish themselves, explore the viability of a business under a mark. But if there is no genuine intention to establish or explore that viability, and instead they intend to enforce the registration across the full specification, then that can be objective, relevant, and consistent indicia that they didn't obtain that trademark right in accordance with the functions of a trademark, but for something else. And as I've said, the inference can be displaced by an explanation of appropriate commercial rationale, but a failure to provide that explanation may reinforce the inference. The big question then is commercial rationale. Is it or is it not present? So if you're advising your clients, you might consider whether there's any prospect of use at all, and if not, whether there is any commercial justification consistent with the trademark system and the function of the trademark. And just touching, before we move on to the second consideration of the Supreme Court on enforcement, which I mentioned a moment ago, and this is not necessarily going to come up in every case because Sky is a very special case, the Supreme Court took exception to two things that Sky did throughout the claim. The first is that it initially relied on all of those thousands of terms covered by its registrations against SkyKick. So I mentioned that among those thousands of terms, things like whips and bleaching preparations, those were relied upon against SkyKick, which was offering things like email services, for instance. And secondly, the highly active policy that Sky took of policing its marks. The Supreme Court took both of those things and said that they lent powerful support for SkyKick's case that Sky had secured registrations for goods and services for which it never had any intention to use. And despite that lack of intention to use, Sky was prepared to deploy the full armory, in the words of the Supreme Court, at its disposal to prevent or block another trader, even where there's no likely confusion and wouldn't amount to passing off. This is clearly something which the Supreme Court found to be deeply unattractive, and I think it really encapsulates the evil that it's trying to prevent with this decision. But for our purposes as well, what it shows is that as two additional factors that can be useful indicia of bad faith are enforcement history and pleading strategy. And this moves me on to the second consideration then of the Supreme Court, which is broad terms. So we have lack of intention to use and a breadth of the specification, and then we move into broad specific terms themselves. And as you might imagine, these present a bit more of a problem because an applicant could intend to use for part of those terms. So if you take cosmetics, for instance, you might intend to use for lipstick and blusher, but you might have no intention to use for anything such as eyeshadow, mascara. Supreme Court confirmed that an application can be made partly in bad faith here, insofar as the term covers subcategories. So the first point there is that there's no get out by using a broader term to try and carve yourself out a wider scope of protection. What do we do with this? Well, the way of dealing with those terms is to adopt the so-called blue pencil approach, which we find in revocation cases. And what that means is an applicant does not need to have a commercial strategy to use for every possible species of goods and services covered by a term. That would just be unwieldy. But where there are distinct subcategories covered by a general term, it could be bad faith to apply for that general term. So you can't escape because it's general, but there is going to be a bit of a balancing act carried out by the court. And the classic example given is computer software, because there are many, many, many different subcategories covered by computer software, which are hugely different from each other. And I just want to draw your attention to a very recent judgment that came out, which is Wise Payments against Withwise. And in that judgment, the court did find for computer software that it was bad faith to apply for the term as a whole. And so this was amended down to very specific forms of computer software. And likewise, we have the PAN 1/2025, which came out recently, which advises caution and due consideration when applicants are using general terminology. And the examples given in the PAN are computer software, pharmaceuticals, and clothing. But of course, there can be no clear-cut rule. PAN makes it clear that for some applicants, that terminology may be good faith. That may be a good faith act to cover it and maybe a reasonable claim for their business. But for others, it won't, and it'd be more appropriate for them to select subcategories. So there's still quite a number of questions open, but we are getting more guidance filter through. And this moves me on then to the conclusion and takeaways for SkyKick. Well, first is that we effectively have more guidance on category 2 abuses for bad faith. That size and width of specification can be a factor in bad faith, the nature of the business, the reasonability for application, commercial rationale, and the enforcement strategy that's being used to deploy the trademark, but not reputation. Ultimately, the question is it reasonable to infer bad faith, taking these factors in the round? And I think the biggest impact this is going to have is the way we plead now in both registry and court cases, because enforcement factor and pleading factor in. It's going to be necessary to take a much more judicious and selective approach. And it may then be that the approach where everything is relied upon from the beginning and then dropped in a skeleton argument are likely to be rowed back, at least in these kind of cases where we're dealing with a very large number of goods and services. The second thing to conclude upon is that bad faith is not all or nothing. It does not affect the entire specification. And leading on from this, when we're thinking about general terms, we're back to the modus penumbra approach, which Arnold set out in the trial judgment, which effectively mirrors genuine use. Taking these two things together, this is why I don't think that SkyKick will change filing practices all that much because of the lack of infection. There's no real downside at the moment for an applicant to claim a wider scope of protection. And I say this because Sky's practices themselves were pretty remarkable. So covering 8,000 odd words in the specification is not the usual order of things. I think for the everyday, that combination of wide and narrow terms, which has been the practice ever since SkyKick really reared its head, would still seem to be acceptable. And I think this will likely continue, at least for now. But what it is useful to do is apply that test of reasonability and commercial rationale when you're advising your clients, and noting that if you can show commercial rationale consistent with the origin function, you're likely to be okay, as long as you're not arguing that your rationale is for reputational enforcement purposes. And so really, I think what this is going to do is get rid of the mad terms, so your whips and bleaching preparations, where you've got no business connected to those. But in addition, the fact that you can surrender or divide part of an application, if you really don't want your application or your registration to be snarled up in proceedings, may mean that the impact is somewhat limited realistically. But you should consider that new PAN, which I've mentioned, and draw your client's attention to the behaviour expected of the applicants. the registry is very clear that it can't prescribe what will and won't be bad faith in advance, as it is going to be fact specific, but that applicants should seek registration for goods and services which represent fair and reasonable claims in the context of their businesses. So this is all, again, reasonability, looking at what it might be reasonable for your clients to cover, consistent with the origin function, but at the same time, weighing the fact that at the moment, the impact would seem to be somewhat limited. So that takes us through a whistle-stop tour of Sky and SkyKick. I hope that's been useful and that's helped you get to grips a little bit with what the judgment is and why it's important. And that just leaves me to say thank you for listening.